give us a reasonable time because they know that there's a COVID shutdown right now and state of emergency. So they have given us sufficient time to get the matters for them. It's basically it, not anything great. And then we will hear from them again as to the sentence for each person separately.
So it is possible that the Court of Appeal will reduce the sentence?
Oh, that's a possibility. I think that is a real possibility.
But where it relates to getting him off completely, you'll have to go to the Privy Council.
Correct.
Okay, thank you.
But it means to me, ladies and gentlemen, that the trial, it looks small to you, but to us as legal persons, the fact that they are looking at reducing it is something that inures to our benefit. So we will pursue that with the usual vigor.
Right. Well, any ideas though? Vybz seem to have been in positive about the possible outcome. Any particular reason why he would have?
Yeah, would have been positive.
Outside. I mean, he seemed almost certain.
Yes. Well, listen. It's like everything in life. You face a situation which can have dire effect, and you remain positive because positive is what carries you through. As I tweeted yesterday, you remain positive because the other options are just not what you...
Not options.
Yeah, they are not options. But frankly, I believe he was emboldened by the level of the representation and the grounds of appeal because we gave him copies and we still are of the view that they are good grounds.
Yes.
But we don't make those decisions. That's why we are lawyers. We argue until we get what we are satisfied with and or when we can't argue anymore.
With COVID running rampant, do you have any ideas to say when that process with the Privy Council would even be able to begin?
That's a very, very, very important question. But we have to go to the Court of Appeal here for leave. We just don't go up there. We have to go for leave here. So there's an intermediate stage before we get there. But sometimes it will take a year, thereabout. It's not a quick process.
And that's under regular circumstances?
Yes, under regular circumstances. It's not a quick process. But of course, the UK is under so much stress now, we don't know when the courts will be up.
In a case like this, would you now confirm that it would be best if the Caribbean had their own court so that we wouldn't have to go to the Privy Council?
Oh, why did you ask me that question? I don't believe many people agree with me, and some attorneys certainly don't agree with me. We have had many arguments about this, and it's not because our intellectual level in Jamaica or in the Caribbean is any less than anywhere else. We have brilliant jurists here. And I have read a lot of judgments from the Caribbean Court of Appeal, and I've been kind of shifting my position towards the Caribbean Court of Appeal, Court of Justice. But right now I still am in the arena of matters, criminal matters, going before the Privy Council. We have had experiences there. We have been fully listened to. And one of the most important things is that there has been no bias. The Privy Council, they don't know who vybz Kartel is. They don't know who Valerie Roberts is. And frankly, they don't care either. So, to me, our arguments are devoid of any bias.
So you believe you'll get a fair trial at the Privy Council?
I believe we will be listened to. I believe the grounds are substantial. And I believe most of all that no justice system can survive if we don't have fair trial. And that is where this team puts their emphasis. I was alarmed at how this trial proceeded, and I believe all accused persons must get a fair trial. If a jury, having heard all the evidence and it's being properly put before the jury, and they take the decision, then that's where it rests. But I am not satisfied, and that's my professional view and my personal view.
I think I just answered that question, but let's get one more.
Yes.
I see you keep making reference to your trial. Just a particular, but in terms of the unfair trial.
Okay. Luckily, I refreshed my mind last night, my memory last night. There was a lot of text messages taken from phones. And one of the things that the prosecution's evidence revealed, this is not defense witnesses, is that the phone from which these text messages were taken was placed in a locker by the police officer who received it, and that the key for that locker was placed on top of the locker, and that persons would have access to the phone. In addition to that, I believe that there were several days, there was material on the phone on the 9th, 10th, 11th, 12th, maybe the 13th and the 14th, which indicated that the phone had been used. That is, somebody was handling the phone. Now, in those circumstances, you can delete, you can change context of messages, texts, you can add. So in our view, the phone was compromised because you can manipulate that, and we didn't feel that that should have been left to jury, and the jury should have been made to rely on it. Yes, that is just one of the areas that I believe was important. Also, there was cell site records that indicated that when the witness said he was in a particular place, the cell site information told he was over important. In addition to that, at the time that it is said that this thing occurred, the hospital records show that Mr. Palmer was not in Havendale. So, those are just a few I can remember, but there's a lot of material, including pre-trial publication, negative publications. I think you, the media, might remember that there was some burning down of some digital wires or material, and it was being said that, by the authorities who should have known better, that it was linked to the case while the case was going on. Those are things that create prejudice and bias, and we believe that those would have impact